Hello, I am Professor Gatmaitan. I've been asked to give a brief talk about the Ration Decidendi and the Obiter Dictum. These are concepts that are important in the study of law. Okay. The Ratio Decidendi, sometimes called the reason for the decision, is the ultimate issue before the court and expressly decided in the course of the consideration of the case. That means it is a resolution of an issue that was brought before the court. The effect is that it becomes precedent. Notice that in Dario versus Mison, the court distinguishes the impact, or rather, ratio from obiter. Here, dictum, okay, is instantly different and inferior the way the court explains it. Okay, don't worry about these Latin terms. We'll clarify everything in a minute. Okay, when it is the ratio, it becomes precedent. That means it becomes doctrinal, it becomes part of the law of the land. How is this different from obiter dictum? We have a few definitions in case law that explains what obiter dictum is. And typical of these definitions are the ones that I have collected here. It is an opinion expressed by a judge incidentally or collaterally and not directly upon the question before the court. So it is not said to resolve the issue that was brought before the court. So we see immediately how different this is from the ratio. The ratio, as we said earlier, is a resolution of the issue. So whatever the court says in that regard constitutes precedent. It becomes precedent. Okay? And when it is mere obiter dictum, it lacks the force of adjudication. That means it's not doctrinal. You're not creating a doctrine in that case, and it's not precedent, so it's pointless to cite that decision. Here we have another definition of obiter dictum. It is an opinion entirely unnecessary for the decision of the case. Literally, if you cut it out, you would still have a complete case. Okay, that's how useless it is. It's just something that the judge or the justice just happened to say in the course of resolving issues, but they are not intended to resolve the issues themselves. They are said collaterally. By the way, you know. So there, the distinction should be clear. One is important, the other is not. One makes doctrine, and one makes law, the other does not. Okay, let's try to clarify these concepts. Again, if it's obiter, it's not binding as precedent. Okay. So what's the purpose of knowing what the ratio is? What is the purpose of distinguishing it from obiter dictum? Okay, so if it's ratio, as I said earlier, it creates doctrine, and if it creates doctrine, or it doesn't create doctrine, then it's not precedent. It's useless. You don't cite that case to build up your argument in court because it's not law. That's what obiter is. I think we need to talk about examples. Here is my favorite example of how to identify what obiter dictum is. And some of you may have heard of this case before. It is Oposa versus Factoran, and that is the case where supposedly the Supreme Court of the Philippines recognized intergenerational equity, recognized the right to sue on behalf of future generations, the right to sue for generations yet unborn. And it is a mind-boggling concept, and understandably, it spread throughout the world. It distinguished the Supreme Court of the Philippines from the rest because it's back in the early 90s, and and we catapulted ourselves into environmental, litigation. If we look at the response or the analysis of the decision, for instance, this is a social media card from the Association of Law Students of the Philippines. And in it, we see the prayer of the petitioners. What were they asking for? The children here, on their behalf and on behalf of future generations, were asking the DENR to cancel all timber license agreements and to refrain from accepting and processing new licenses, new applications for licenses. The argument being that the world is falling apart and we should stop this practice. But if you read down here, you'll find out that according to this card, this is a landmark case because it recognized, it made a ruling on the standing of the petitioners. We have standing to sue on behalf of future generations. And this wouldn't be the first time you will find someone making this assessment of the Oposa decision. This, for instance, is a 2010 legal article. 2010. And it still, I think, incorrectly points out that the Philippine Supreme Court in the Oposa decision recognized the right of intergenerational standing. It is a refrain that is incorrectly repeated over and over again. This is a feature on Attorney Oposa because I think he obtained his master's in Harvard after the Oposa case, and we can still see the same kind of interpretation from the entire world. That the court somehow recognized the right to sue on behalf of future generations. I've been saying that all that talk about intergenerational equity is wrong. And I know that after looking at Secretary Factoran's response to the suit. And he actually filed a motion to dismiss the complaint on two grounds. The first one being that there was no cause of action against him. And second, that the issue raised by the plaintiffs is a political question which is to be determined by the other branches of government. That's what a political question is. Okay. The judge who was hearing the case granted the motion to dismiss, and that means he agreed with Secretary Factoran. And in effect, he held that the complaint states no cause of action against the Secretary and that it is a political question. And then he added that what the petitioners were asking for would be an impairment of a contract, which is protected or prohibited under the Constitution. The contract being the timber license agreement. So in effect, the dismissal of the case had three grounds. Lack of cause of action, it's a political question, and the impairment of contracts, which cannot be allowed under the Constitution. Now, is it true that there was no cause of action against Secretary Factoran? And this is now the Supreme Court evaluating the lower court's decision. And the Supreme Court disagreed, and it said that a denial or violation of the right to a balanced and healthful ecology, which is found in Article 2 of the 1987 Constitution, creates a right, a duty rather, on the part of the government to respect that right. And the failure of the Secretary to protect that right creates a cause of action. So if the issue is there a cause of action, then yes, because evidently the Secretary has failed to protect our right to a balanced and healthful ecology. There is a cause of action. On the second ground, was it a political question? Was it something better addressed to Congress or the President? And the Supreme Court disagreed. What is involved in this case, said the court, was the enforcement of a right versus the policies already formulated and expressed in legislation. In other words, it's already there, you know. So this is not something that Congress has yet to do because the policies are already expressed in legislation. And the court also adds that besides, the political question doctrine is not insurmountable anymore. Probably discuss this better in constitutional law. But it's not as formidable as it used to be. So it's not a political question either. On the third ground, was there an impairment of a contract which would be prohibited under the Constitution? And again, the Supreme Court disagreed with the lower court. And it says that all licenses may be revoked or rescinded by executive action. This is not property that is protected by the due process clause. A timber license agreement is not protected by the non-impairment clause. Okay, and if public interest demanded it, the executive branch can cancel timber license agreements. So what exactly did the court do in that case? Well, it remanded the case to the lower court and asked that the persons holding timber license agreements be pleaded in the case, presumably to be able to defend their interests. Okay, but notice the Supreme Court didn't cancel any timber license agreement. It didn't. It went back to the lower court, essentially instructing the court to try the case. Okay, and Tony Oposa did not pursue the case. And in fairness to him, I don't know what you would do if you were in the lower court. I mean, what would you ask the timber license agreement holders if they're violating your right to a balanced and healthful ecology? I don't know. In any case, he didn't pursue it, and it died a natural death. In the meantime, we were celebrated as a very progressive country with a very, forward-looking Supreme Court. So, why are people citing Oposa for intergenerational equity, for the right to sue on behalf of future generations? It's because the Supreme Court actually talks about standing to sue for future generations before it discussed the actual issues that were raised. This was a procedural matter, said the Supreme Court. But it also said that the defendant, Secretary Factoran, did not take issue with this matter. That means it wasn't an issue in the case. And whatever the court says about it would never constitute doctrine and would never constitute precedent. So, what do we do with that discussion on standing to sue on behalf of future generations? Nothing, because it's all obiter dictum. This, the most cited part of Oposa, both here and abroad, is all useless because it's obiter dictum, because nobody had a problem with standing to sue. So whatever the court might have said about it was not done to resolve an issue, and therefore it's obiter dictum, therefore it doesn't constitute doctrine or precedent. Is it completely useless? No. A subsequent decision of the Supreme Court may adopt what was otherwise obiter in an earlier decision, but it has to be raised squarely as an issue. In other words, there has to be a case in the future where somebody says, well, the respondent, for example, would say the petitioners have no standing to sue, and then they can adopt Oposa. And until then, everything the court says about intergenerational equity is obiter dictum, not doctrine, and therefore, no, it has no value as precedent. You want to read the cases very, very carefully, okay? Or else you will find yourselves in a situation like this, where your professor asks you the ruling, for example, in the case of resident marine mammals versus Reyes, and you will, enthusiastically but incorrectly belt out marine mammals have the standing to sue. The professor gives you that look, and then you realize you didn't read the case. You didn't read the case carefully. This one, even the media got correctly. That the Supreme Court said, you have to have a human being sue on your behalf. But by yourself, all the marine mammals cannot sue. So don't get too excited. I'm saying this because every year, in the first semester, someone always makes that mistake. Someone always makes that mistake because they do this. They rely on a digest that someone had already written years ago, and it's wrong. And this is how most law students survive. They are distracted by what is convenient and attractive in the sense that it's short. Okay? Where your responsibility really is to read the case in the original. Read it. And many of you will say it's too long, they're too long, it's impossible. And if you have that attitude, if you keep saying it cannot be done, then you will never be able to do it. And yet generations of law students before you have done exactly that. Read the case in the original. Makes you a better student. You learn more.
That is why you fail.
This happens to you. Okay, now let's talk about another case to illustrate what we mean by obiter and the Ration Decidendi. Let's talk about the recent case of Pangilinan versus Cayetano, and this is the case involving the unilateral withdrawal of the president from the Rome Statute. It's in the news. So the issue here, or rather the controversy, revolved around whether the president by himself could do this, withdraw from a treaty. And a number of senators were of the opinion that it could not be constitutionally done, and that their consent, because they gave their consent, rather concurrence to the treaty, this concurrence is also necessary for the withdrawal from that treaty. Okay, that's basically the argument. And the press, when it finally got hold of the decision, kept on focusing on those provisions of the decision told the president that he cannot dodge the investigation by the ICC by citing the withdrawal of the Philippines from the Rome Statute. The press insists that the Supreme Court made this ruling that the president could not arbitrarily terminate international agreements without the concurrence of the Senate. And if you read the case, you would do what Thor is doing here. Did it really? Essentially, the question being asked there is, did the Supreme Court really make these holdings? make these findings? Are these doctrinal? Is this the Ration Decidendi of the case? The issues, or what the senators were asking for, were for the Supreme Court to declare the withdrawal invalid because it lacked the concurrence of the Senate, and then to notify the UN Secretary General that it was canceling, revoking, and withdrawing the instrument of withdrawal. Those are the only issues. And what did the court rule? Well, in the end, if you look at what we call the dispositive portion, or the decretal part of the decision, or the falio, there's so many names for this. The Supreme Court said the petitions are dismissed for being moot. So the case got thrown out on a technicality. And it was too late to do anything about this case because it was now moot. So if you had gone on to read the entire 100-page decision of the Supreme Court, you will realize, or you should have realized, that all of this is obiter dictum. None of it is binding, because that is the only ruling it made. The only ruling it made is that this case is moot and therefore we are dismissing it. What is the dispositive portion? Well, it's that part that starts with wherefore, but the there is a conflict between the body of the decision and the dispositive portion, the latter will prevail, because the theory is that the dispositive portion is the final order of the Supreme Court. Okay, and the opinion, the body itself, is merely a statement which orders nothing. So if we want to know what the Supreme Court really ordered, really said, then we go to the dispositive portion. It helps us determine what the ratio decidendi is. And in this case, the case is moot. That's the ratio. I mean, that's the only ruling that the Supreme Court made. Is all the discussion in Pangilinan versus Cayetano useless? Again, I'm saying that when the next case comes up, when the next president withdraws from another treaty, litigants can cite the discussion in Pangilinan if they like the discussion, but the Supreme Court is really not bound by any of it. The Supreme Court can say, well, everything we said there is really obiter dictum or dicta, because we only really made one ruling, and that is that the case is moot. So they can actually rewrite everything. If you don't believe me, we had a recent forum on this issue, and everyone agreed with me. We had as guests Justice Carpio, Justice Bibi Mendoza, Judge Pangalangan of the ICC, and my fellow panelists here. Everybody agreed that what the court said in Pangilinan versus Cayetano is really obiter dictum. And there's the link to the entire webinar at the bottom of the screen in case you want to listen, in case you haven't listened to the discussion. Okay, so let's review. We identify what is the ratio of the decision to know what part of the case constitutes doctrine. Otherwise, what isn't doctrine is mere obiter, and it doesn't create precedent. There's no point citing it. Okay? You lose your case. And if the court doesn't like you, they'll make fun of you before you lose your case. Or in the process of making you lose, they're going to have fun with you. Okay? So, read the cases, not the digests. You do it because it can be done.